topic. Okay, so this is the last part in incorporation where we are going to do the doctrines, remaining doctrines. There are 2 doctrines still remaining. So those 2 doctrines will do. Some questions in the MCQ will go through. And then you almost have received a PDF for the MCQs. Yes?
Yes, ma'am.
Then we'll take up the discussion of that. Okay?
Yes, ma'am.
And as discussed, next week, then we'll be taking up with deposits. And then we are done with the company law. After that, we'll start with the other laws one by one. Every week, one law, and we'll close it. Okay, everybody? All right? Okay. Let us continue. Yesterday, the last thing that we did was doctrine of ultravires. Okay? For a quick recap, doctrine of ultravires simply means that any action done beyond the power of the company, beyond the memorandum, or beyond the act by itself, then those will be considered to be ultravires and will be called as void contracts. That means they will not be enforceable in the court of law. Neither the company nor the outsider will get any right coming out of these kind of contracts. So they will have no legal effect at all. Ultimately, they will be void, scrapped. They are void ab initio. Okay. But those contracts which are ultra vires the directors, that is beyond the power of the directors, or ultra vires the articles, that is beyond the power of the articles, they can be ratified by the company, by the shareholders. Okay. Now, here we did the case law of Ashbury Railway Carriage and Iron Company Limited versus Ritchie, wherein we understood that in their object clause, they had something with regard to mechanical engineering and general contractors. And because the word general contractors was there, they had financed Ritchie for railway line. And then the company realized and the company repudiated the contract. But then Ritchie bought a suit against the company for continuing the contract. Okay, but this was not entertainable by the court. The court disregarded this thing because it believed that general contractors and mechanical engineering should not be read separately. Rather, general contractors should derive its meaning from the word adjacent to it, that is mechanical engineering. Therefore, the company has entered into financing which does not come in between or come within the ambit of mechanical engineering. Therefore, the contract was held as void and had no legal effect, and Ritchie could not derive any right against the company. Clear, everybody, till here? Yes, everybody?
Yes, ma'am.
Yes, ma'am.
Okay. Let's move on to the next one, doctrine of constructive notice. Okay. Now, in doctrine of constructive notice, if you remember the last time when I told you very easy way of remembering. It is constructive notice C. Okay. So it works in the favor of company. Am I audible to all of you?
Yes, ma'am.
Yes, ma'am.
Because here I'm getting a message, my internet is unstable. Sarvani, can you hear me? Okay. 1 second. Huh? Is it fine now? Yes, Vashri, can you hear me now?
Ma'am, your video is paused, but your
Now is it fine? Okay, everybody now? Okay, all right. I'm audible now? Okay, all right. Now, so we were talking about doctrine of constructive notice. And in constructive notice, we understood in the last sessions when I taught you that it is very easy for us to remember because C stands for constructive notice, correct? And C means it works in the favor of the company. All right. Now, what do you mean by constructive notice? That means everybody knows about it. That is called constructive notice. Okay. So what does this doctrine talk about? This doctrine says that once the memorandum and the article gets registered with the registrar of companies, they become public documents. That means any person can have the access to the memorandum and the articles. So it is an assumption or a presumption that we can say that anybody who's going to enter into contract with the company or going to have any dealings with the company is presumed to have knowledge of the memorandum and the articles. And we are going to understand that everything they have understood in the right sense. That is the way it is meant to be understood. So there will be two presumptions holding good. One is that they have read it and understood it. Second, interpreted in the right sense. Okay. Now, suppose tomorrow, while dealing with the company, if something goes wrong and that was not given in the articles and the memorandum, and the third party was ignorant about it, can the company be held liable here? No. Why? Because you were reluctant. It was understood that memorandum and articles both are public documents. So when you enter into the contract with the company, we want you to read those documents and then enter. If you entered without reading the documents of memorandum and article, and then something goes wrong, then company will not be responsible. Who will be responsible? The third party. Can they bring any action against the company? No. Logic is simple. We kept it on the public portal. We kept it open for inspection. It was a presumption held by us that you will read the memorandum and the article both and only then enter into a contract with us. Tomorrow something is going wrong in the contract because of memorandum and article, then the third party will get no right against the company because the doctrine of constructive notice will come in way and say you should have read the memorandum and the article. Clear, everybody? Like there is a case law of Kotla Venkat Swami versus C Ramamurthy. Okay, yes, it is Kotla Venkat Swami versus C Ramamurthy, where there is a mortgage deed which has to be executed. Okay, I'll give you time to read. First, listen to what I'm telling you. Okay, there was a mortgage deed which had to be executed, and in the articles of the company, it was very clearly written that a mortgage deed will be valid only if it has 3 signatures: managing director, working director, and company secretary. The secretary. There had to be how many signatures? 3 signatures on the mortgage deed for it to be valid. Then what happened was, this company executed a mortgage deed which had only 2 signatures, one of the working director and one of the secretary. And the other person accepted the mortgage deed. Tell me, is this mortgage deed valid? No, it is actually invalid. Later, it was held that the mortgage deed is invalid. Then the third party wanted to sue the company. But can he sue the company? No. Why? It was clearly given in the articles of the company that the mortgage deed should have 3 signatures. But this had 2 signatures. Then on the very first, how did you accept it? Correct? So here, whose mistake will be highlighted? The outsiders. Because doctrine of constructive notice hold goods here. What they say, as per the articles, we had told 3 signatures are required for the mortgage deed to be valid. Then how did you accept a mortgage deed having 2 signatures only? So on the very first, you have been wrong because you failed to read the articles of the company and you entered the contract like that. Here, we are going to uplift doctrine of constructive notice and you will get no right against the company. The mortgage deed, though it is invalid, can you sue the company for that? No. Why? Doctrine of constructive notice works in the favor of company. Did you all understand? But here, two things. You should have read the memorandum. You should have read the articles. And something that you're doing wrong is because of wrong memorandum and wrong article. That means that content should be there, present there. And then it goes wrong. Only then constructive notice will hold good. Are you understanding? Like, for example, suppose you are only into selling, trading, but you are purchasing raw material for some production and you got the supplies. Now, can the supplier recover money from you? No. Because in the memorandum, it is clearly given you are trading. Then why will you purchase the raw material for production? So he supplied you without reading what? Memorandum. So can he sue or bring action against you? No. Doctrine of constructive notice. Is the logic clear, everybody? Okay. So here they have given you two case laws. One of TR Pratt versus ED Sasun, not required. You do only one, Kotla Venkat Swami versus C Ramamurthy. And the other one where they have given, TR Pratt Limited versus ED Sasun, that you can just read the facts of the case. Okay. So that suppose in the exam, a question comes having similar facts, you'll be in a position to understand. But for you to learn here, I think Kotla Venkat Swami versus C Ramamurthy will be enough. Okay. The other one, just have the reading of the facts of the case. By chance of a case studies question having similar facts, you will understand it is captured from here. Clear, everybody? Yes. So all of you, please come to page 2.42. 2.42, Doctrine of Constructive Notice. Read everything given there along with the example. Yes, before entering into the contract. After entering into the contract, you cannot. Yes, it will be available only before entering the contract. Yes. Done, everyone? Okay. Look at the questions given there. May 2003, November 2018, which they give briefly explain the doctrine of constructive notice under the Companies Act 2013. And November 2018, explain where doctrine of constructive notice will apply. Both of them, the answer will be similar. Okay. Always remember, whenever they ask you to define a concept, and if there is a corresponding case law to that, you have to mention the case law also in the examination. Okay. So when they only question you, write a short note on this or that, then be very particular that you write the case study along with it. Okay. If it is a very particular question about it. Clear, everyone? Okay. Shall we continue? Okay. Now comes to doctrine of indoor management. Okay. Doctrine of indoor management is completely the opposite of doctrine of constructive notice. That means it will work in the favor of the outsiders. Okay. Now, this doctrine very simply says, we are not bothered with internal irregularities. Indoor management. What is happening internally with the management, we are not concerned with it. So the outsider should not be punished because of internal irregularities. Okay. What do you mean by this? The meaning of this is, we say the outsider should have complete understanding of memorandum and the articles. Fair enough. But what is happening inside the company? Is the outsider required to know about it? No. Therefore, if there is internal irregularity, because of which something is going wrong in the dealing with the outsider, can the outsider be blamed for it? Can the outsider lose a right because of it? No. Did he read the memorandum? Yes. Did he read the article? Yes. Did he understood them? Yes. So his duty is only up till that. Based on that, he entered into a valid contract. Now, while executing this contract or while entering into the contract, the company in the internal management has done something wrong. How will the outsider be responsible for it? Correct? So we cannot have only one side traffic. So we cannot say only, company can be safeguarded. There should be something for the outsiders also. So to safeguard the outsiders, we have a doctrine which is called as doctrine of indoor management. Okay. This doctrine simply says it is going to work in the favor of the outsider. If the outsider knows the memorandum correctly, knows the article correctly, then we don't expect him to understand the internal irregularities. Tomorrow, if there is something going wrong in the internal irregularities, then he will not lose his right against the company. That means he can very well sue, get the compensation or claim for damages from the company under the breach. Understandable, everybody? This doctrine, very famous case law, we have a landmark judgment here, because of which the doctrine itself is called by that name. What is the name? It's called as the Turquoise rule. Okay. So we have a very important landmark judgment here, the Royal British Bank versus Turquoise. Okay. In this, what happened was the company was allowed to borrow, okay, amount up to a certain limit only after shareholders' approval. So who had to give the authorization for this? Shareholders. The bank had properly read the memorandum and the article, and they very much knew that the company had the borrowing power. And they also knew that directors could borrow after the authorization coming from the shareholders. Now, the directors went to the bank to borrow the money. Okay. So obviously, whether the bank will be knowing whether resolution is passed or not passed? No. It is internal. Passing a resolution, obtaining permission from the shareholders is something internal. Do you post a general meeting on the website? No. It is going to be internal. So whether they have taken the permission or not taken the permission, will you know about it? No. So that was internal irregularity. So what the directors did, without obtaining the permission or without obtaining the authorization from the shareholders, they went to the bank and raised the loan. Tomorrow, what happened? They could not repay. So the bank filed a case against the company. Tell me, will the banker lose the right here or will he still have the right to recover money? He will have the right to recover the money. Because did he know about the articles? Yes. Did he know about memorandum? Yes. Not obtaining authorization from the shareholders is internal management, internal irregularity, which the banker did not know about it. So can he recover the money? Very much yes. Doctrine of indoor management will be uplifted here. Is the concept clear, everybody? But two conditions. You should know the memorandum, you should know the article, and you should not know the internal irregularity. These two conditions have to be fulfilled. Knowing the memorandum and the article and not knowing the internal irregularity. If you know there is internal irregularity and then you give the loan, then you are a mistake. Is the concept clear? Understandable? So two basic conditions. You should have knowledge of MOA and AOA and do not have the knowledge of internal irregularity, Only then you can use the doctrine of indoor management, where you will be protected. You can sue the company and recover the money from the company. Is the concept clear, everybody? Understandable? Yes. Now what you do is, from your material, only read up to conclusion. Don't read exceptions. Exceptions I will take you through. Do not read exceptions. Once you're done, please ping me on the chat box. Understandable, all of you? Most of the times, one question from here will be coming, one of the three doctrines. Okay, for sure from this topic, one of the doctrines, direct or indirect question will be asked. Okay, so be prepared for it. Done, everyone? Shashikiran done? Nitya? Vaishnavi? Shashikira not there? Vaishnavi? Sukendra? Nobody is there? Then. Okay. Chandra Kumari? Good. Okay. So Vaishnavi and Shashikiran, I can't hear you, okay? I'm waiting for the reply from your end. If it does not come, I'll understand you're
Yes,
not there.
ma'am.
Ah, good. Where were you? Good, okay. So Vaishnavi also is there, okay. All right, let's continue. Exceptions to doctrine of indoor management, okay? What do you mean by doctrine of exception to doctrine of indoor management? Will the outsider be protected? No. That means again here, it will be in the favor of company. Okay. So it is an exception to doctrine of indoor management. Now, understand, in the company, insiders are going to be aware of the irregularity. Can the director of a company say he did not know about the internal irregularity? No. Okay. The meaning of that is, the first one exception is knowledge of irregularity. What is it? Knowledge of irregularity. Here, it is very clearly said that if the directors say that they do not have the knowledge of internal irregularity, will the other party accept it? Will the company be responsible for it? No. In this case law, that is Howard versus Patent Ivory Company, what happened was the directors were allowed to borrow only up to a certain limit without the authorization. Above that limit, if they want to raise the money, they have to take the shareholders' approval. Okay. But what directors did, they themselves lent the money to the company for amount exceeding the limit. Okay. Now, can they tomorrow tell, we didn't know about the internal irregularity, that the authorization was not given by the shareholders? No. Because they are internal part of the management. Whether meeting is held or not held, will they not be knowing about it? They will be knowing about it. So can they claim here doctrine of indoor management? We didn't know, authorization was not given, so we gave the loan of 3,500 pounds. Do you think they'll be having the right to recover this money? No. You are insider, you are the inside part, the most important part of the internal management. Whether meeting is held or not held, you will not be knowing about it. You will be knowing about it. In fact, you will be a part of the meeting. You will be the persons or you will be the members responsible for conducting the general meeting. So obviously you'll be aware of everything. So can you claim that you didn't know about it? No. That means if you have the knowledge of irregularity, can you take the help of doctrine of indoor management? No. If you knew about the internal irregularity, you will be held responsible and you will not get the benefit of saving yourself under doctrine of indoor management. Is the concept clear, everybody? Okay. Yes. All of you, the first one, knowledge of internal irregularity. The first one. Okay. Come on, quickly do the reading. Also read the case law along with it. क्या काम है फोन से Easy, everybody? Yes? So all those have studied the CA foundation also, not the direct entry people, but those who did CA foundation. This was there a part of foundation also? So now it looks even more easier, right? Or in foundation, bouncer? No? Yes or no? You understood in the foundation also? Good, okay. All right, so it is like a revision, okay? All right. Then, next one is, I will give you an example, you tell me this, okay? Suppose I have bank account in ICICI Bank, okay? Wall Street is working with me. She is my employee, okay? my employee, that is Vashri, goes to the ICICI bank manager and says, from today, whatever checks come in the name of ma'am, you transfer it to my personal account. What Vashri is telling? Whatever comes in the name of ma'am, that is whatever comes in the name of Pradnya, you have to transfer it to my personal account. Tell me, will the banker do this without cross-verifying with me? So whatever payments I have to receive, whatever checks I receive in my name, you have given the instruction to the banker that look, whatever comes in her name, you have to transfer to my personal account. That means check received in the name of Pradnya to be credited in Vashri's account. Tell me, will the bank manager do this without cross-verifying with me? And if the banker does this, transfers all my checks to Vashri's account, will I keep quiet? So can the banker then tell, I didn't have the knowledge of internal irregularity? Can he do this? No. See, when there is a suspicious transaction, you know there is something suspicious and you're negligent about it, you don't inquire about it, then can you claim doctrine of indoor management? No. So suppose if the company, okay, you go to the banker, okay, and there is an account maintained with the bank of the company, and one of the employee of the company goes and tells the banker, whatever comes in the name of company, you deposit in my personal account. Will the banker cross-verify with the company first? Then have you given such instruction? If the outsider does not do the inquiry with the company and go on depositing the money of the company in that personal account of the accountant or somebody, will the company leave the banker? No. Will the banker tell doctrine of indoor management? One punch they'll get on their face. Are you understanding why? Because when there is a suspicious transaction, when something is dubious, something is bad, and if you're quiet about it, you're negligent about it, how will you claim the doctrine of indoor management? It is very obvious in the scenarios that you need to do something extra and then hit the transaction. Otherwise, you cannot. Is the concept clear, everybody? So next is what? Negligence. That is suspicious circumstances or unusual magnitude of transaction. Unusual means what? Magnitude is size. Okay. Now, suppose in Vashri's house, there is a computer to be bought. Okay. There's a computer to be bought. Tell me, can she place the order or will the parent place the order? Who has to place the order?
Parent, ma'am.
Correct. On the same parlance, in the companies also, if suppose building has to be purchased, can the accountant purchase the building? Or the board should purchase? The board should purchase. And if the third party has entered into contract with the accountant to sell the building, will it be enforceable? No. That person had to contact the company and inquire, did you really sanction the purchase of building? And if they have not done, and tomorrow building is gone, will the company be held responsible for this? No. Company says, that accountant he is. How can you execute a sale deed with him? Where is the board gone then? Are you understanding? So where there are suspicious transactions, something irregular, the magnitude is very big and nobody is bothered about it to cross-verify, then the outsider cannot claim doctrine of indoor management. That is the next exception. Where there is negligence about what? Suspicious transactions. About unusual magnitude of the transaction, you are quiet. Then can you claim? No. You will not be protected. Okay? You cannot claim from the company the loss that you have sustained. Clear, everybody? Yes. Next one, please read by yourself. Both the case laws you can read. Anyone you can write in the examination. I would prefer you write Underwood versus Bank of Liverpool. Easy, everyone? Varun? Bhargavi?
Yes, ma'am.
Varun there? Okay. Ankita? Okay, good. Now, this doctrine of indoor management is based on two principles. One is you should have knowledge of articles and knowledge of memorandum, and you should not have the knowledge of internal irregularities. Correct? So the next exception is no knowledge of articles. So if you do not have the knowledge of articles, that is articles of association, can you claim doctrine of indoor management? No. Because the main rule you're skipping. So can you claim the doctrine of indoor management here? No. So if you have not read the articles of the company and then you enter into contract with the company, later because of some default, can you claim doctrine of indoor management? No. So the next exception is no knowledge of articles. What I would want is you read only the facts of the case. Okay, they will not ask you this separately. Only know the facts of the case because similar kind of case study question could come. Okay, so just have one reading of the case study given there. You don't have to by heart this. Okay, come on quickly. The next one, no knowledge of articles. Done, everyone? Good. Okay. Now, illegal transactions. Ever can you claim anything? They're void. So if you do something illegal and you say doctrine of indoor management, can you do that? No, because they are void. Illegal means what? Ultra vires. Okay, beyond the act, beyond the law. Okay, if you do like that, can you ever claim any doctrine rather? No. So exception to doctrine of indoor management. Okay, then last one is forgery. Okay, now in forgery there is a case law of Rubin versus Great Fingal Consolidated Company. What is this case law all about? Okay, first of all, you understand what is forgery? Signing somebody else's signature. Correct? That is called as forgery. Is forgery recognized by law? So what is the sentence that we study in contract about forgery?
There is no defect in the consent, there is absence of consent.
Correct. That means law will not say the signature is wrong. Law will say I cannot see only the signature. So if there is a document on which signature is there, correct, it was forged. As per law, the signature is not there only. Correct? So it is as if you have a transferor and the transferee. So there has to be signatures. So whose signature is forged, law cannot see the signature. So is the contract complete? No. Okay. So what happened here was a share certificate was supposed to be transferred to another person. Okay. So the company had to issue a new share certificate. As per the company's articles, a share certificate was to have under the common seal of the company, and it required 3 signatures. One of the company secretary and another 2 of 2 different directors. What happened here was the share certificate was on the common seal of the company. Correct. The company secretary had also signed it. But The two other directors whose signatures were required, their signatures were forged by the company secretary. The company secretary also signed for the remaining two directors. Okay, then what happened? This share certificate was issued to the transferee, to the new owner of the shares. This person said or contended that I did not know about the forgery, so this share certificate had to be considered to be valid. I should be protected. No, I'm the outsider. If default is inside the company, how am I responsible? So according to him, Doctor of Indoor Management should hold good here. Correct? Because he does not know about the internal irregularity. Correct? He knew in the articles 3 signatures had to be there. There are 3 signatures on the certificate. So according to him, everything is correct. He had the knowledge of articles and memorandum and he did not know about internal irregularities. But as per law, forgery is an exception. In forgery, what happens is, law very clearly says, there is no defect in the consent. There is absence of consent. That means as per law, signature does not appear. So when law is looking at the share certificate, how many signatures can law actually see? Only one. 2 director signatures are forged, right? So out of 3, how many can be recognized by law? Only 1. So is the share certificate complete? No. So is the transfer valid? No. Therefore, though the transferee is innocent, even then, can he claim Doctrine of Indoor Management? No. He is fulfilling all the conditions of indoor management. But because it is a unique case of forgery, can he get the claim here? No. Okay, it is a next exception to Doctrine of Indoor Management. Okay, so in forgery, you cannot claim Doctrine of Indoor Management. The certificate will be held invalid even if you did not know about the internal irregularity. Because in forgery, there is no defect in the consent, there is absence of consent. Concept clear, everybody? Yes? Yes. Go through it quickly, all of you. Read illegal transactions, also forgery. Done, everyone? Okay. Now, they have given you questions there. Please come down. All the questions, when you write the answer for it, give the corresponding case law also for it. Don't look at the solution. Look at the question and think which case study will come in. Then cross-check your answer. I'll give you exactly 10 minutes time for this. 4 questions. Do all of them. Read the question, analyze the answer along with the corresponding case study. If it is matching, good show. If not, please question me back. Okay, everybody? Yes, get started. Done, everyone? Okay. Were you able to match it correctly with the corresponding case law? Yes, Deepak? Yes, good. Yesterday, I had given you 2-3 questions for homework. Did you complete them? Don't ask me which, ma'am. We had done some, and I told you the remaining 2-3 you have to do it at home. Did you complete? Really? Which was that? The previous one? I think it was with respect to what was that? Actually, there were 3-4 questions continuously. Then I told you that the 2 you can do it later on.
Page number 2.14.
Page number 2.14. Okay, yeah. These are pre-incorporation. No, yesterday's class also I told you some. Pre-incorporation also will take up one because the remaining 2 are the same. So we'll take up one of those, and so that you'll have an idea of what they are. Okay. So 2.14 also will do one now. But there was something yesterday. 1 second. No? I told you to do it at home. Yes, this one. Page 2.41. I told you in the class to do only A and B. And I told you C and D of ultra wires to do it at home. Correct? Did you do them?
Yes, ma'am.
Good. Okay. Yeah, all of you please come to page number 2.14. Just have a quick reading of pre-incorporation question. 2.11a. They have given you 2 there. One, what the author of this book considers, and one, what is given in the ICI material. Coincidentally, now they match. Okay, earlier they were not matching, but now they match, so it doesn't make any difference. It is indifferent now. You can write any of the answers. Both are same. Okay, read only one. The other 2 are the same. Okay, so you can do 2.11a. Please make the best use of the time given in the class. Do not waste your time. If I cannot see you, does not mean you can fool around or do whatever you are liking it. Okay, see that you make the best use of this time. Done, everyone? Understandable? So are we good to close the topic? Anything that you require help? Only 2 things are remaining. Active tagging of the identified companies, and one more is the one with detailed procedure for converting public into private. We'll do at the end of the law class. Okay, for me it is not very relevant. but we'll not skip it. As I told you, it can be questioned anything in the examination. So we should know everything. But this I will remember and we'll do it at the end of the session. Okay, after we complete the entire syllabus, we'll take this 2 for discussion. Okay, everybody? All right. So are you all ready with the MCQs? Did you receive the MCQs now? Okay. Now first we'll do the MCQs together, and then we will just get started with the topic of deposits. Just start the topic with deposit depending upon the time that we have. Okay. So can we start now? All right. Everybody please open the PDF which you have received for MCQs. Okay. Ready, everyone? Ready, everyone?
Yes, ma'am.
Okay.
Yes, ma'am.
Okay. No, at least 2-3 people respond back. No, at least I'll be knowing that you're listening to me or not. At least type or at least speak up. If I ask ready, nobody responds. Ready, everyone, nobody responds. How do I understand? Okay. And then suddenly everybody will reply. Okay. At least 1 or 2 people do the needful, that you at least reply back at least once to me. Okay. All right. Let's continue. The first one. All of you received mock test number 2? Yes, right? Yes. Okay. Books and papers include books of accounts, vouchers, writings, documents, numbers, and registers. Okay. Which of the option is correct? Read the option by yourself and give me the answer. Okay, all of you will make the chat box to everyone there. Everybody change the setting in your chat box. You are directing the message to me, right? You make it to everyone. You understood? Yes. I want everybody to read the answers that you're giving. So the answer is A. Okay, the answer is A. In branch office, you cannot maintain the company's main books. Okay, so those who have given the answer as C, wrong. Okay, the answer is A. Good. Mr. X, a director of a company, has done a wrongful act and shall be held liable for fraud by application of which principle? Okay, doctrine of alter ego, you have not done it. It was there earlier. You can skip this question, okay? Okay. Okay, the doctrine of lifting of corporate wheel is considered to be doctrine of alter ego, the other name for it. Okay. Lifting of corporate wheel is considered to be alter ego. Okay, so we have not studied this word. It is not given in our material. So you can skip this. Okay. All right. Next. Did you all understand the second one? Yeah, this doctrine of alter ego, it is just another name for lifting of corporate wheel. That's it. Okay. All right. Okay. Next. Mr. Geoffrey Lee incorporated the company as MD of the company, holding majority shares and acting as chief pilot in the company. After his death, decide which of the following is correct. Good. Okay, almost everybody is correct here. The answer is C. Okay. His wife is empowered to receive compensation and as he is separate from his company. Solomon versus Solomon and Company. Correct, everybody? Okay, good. Next. Mr. B is a nominee appointed by a sole member of OPC. Such sole member has died in an air crash. Now Mr. B will become member and shall. Very good. Everybody is right. Appoint a new nominee within 15 days of becoming the member. Good. Okay. Next. Shall I continue? Okay. The company has discovered that one of its promoter has sold his property worth 25 lakhs to the company for 30 lakhs without disclosure. Which of the following remedy can company claim or exercise? Think deep, everybody. What do you mean by refuse to honor the sale?
Does not adopt the pre-incorporation contract.
Correct. So is that acceptable? That is nothing but the remedy, rescind the contract. Correct. Second, do not pay him the profits. Correct. Third, sue for breach for duty to disclose. That is breach of trust. So all of the above, all the three options are available. So all those who gave only the answer as C, why A is possible? Can they refuse the sale altogether? Yes. They can rescind the contract. Refuse to honor the sale is nothing but rescission of the contract. Is this remedy available? Yes. If there is secret profit done by the promoter, three remedies you have. First remedy is what? Rescind the contract. Second remedy is to recover the profit. Third remedy is to sue for breach of trust. Correct, everybody? So all these three are covered. So answer is all those who gave C. Is it clear?
Yes.
Shrishti, Sumaya, Aditya, Viresh, everybody. Clear?
Yes, ma'am.
Okay, good. Next. That will be a negotiable amount, Narasimha, because the thing is, somehow they'll not give them profits. So the answer should be only that he's not paid 30 lakhs. Any amount below than that would be considered to be recovery of profit. Okay, yeah. Okay. Question number 6. 2019 onwards, an application for registration of company shall be accompanied by form named Agile in form number. Registration of company. This even I have a confusion. I think answer is A. Refer your textbooks, everybody. What is the form number? INC 32 is not for incorporation, till where I remember. Yeah, the same topic that we were doing now. See, incorporation of companies.
INC 35.
Yeah, 35 is what is the answer. That's the same one, I believe. Okay. The answer is INC 35. Where do you read it, Nitya?
Ma'am, page number 2.18.
2.18,
18, ma'am.
it's INC 32 given here, right? What is the answer? I feel it is INC 35 only.
Ma'am,
Yeah.
the next para they
Yeah,
gave
it is INC 35 only, correct. It is 2.18. Okay. All of you come to page number 2.18. Come to paragraph 2.14. In Agile Pro, it is INC 35. Got it, everybody? Because I remember reading this carefully. Yes, Agile Pro, INC 35. Okay, as per Spice Plus, it is going to be INC 32. Okay, for Agile Pro, it is going to be what? INC 35. See, these small things you'll come across only after we do such kind of MCQs. Otherwise, we are just ignore this part, right? So small things we come to understand only after we do such kind of things. Okay, that was the main purpose that I'm taking MCQs. Okay, everybody? So you'll be able to understand the thin line differences. Okay, otherwise we all had INC 32, 35, no much doubt about it. But Agile, it is INC 35. Spice Plus, it is INC 32. Okay, so the answer here is C. Sorry, A. Clear, everybody? Did you get the reference from the textbook also where it is? Okay. Now, 7th one. Company with share capital can't do business or borrow money unless form numbers in I told you incorporation topic important. Auditors topic and incorporation topic, form numbers are important. Okay. All those who gave answer A, think again. What is INC 22? That also you should know. Verification of registered office. Which section are we talking about? Is this section 10A? Yes or no? Yes. So two things you have to submit, right? One is the declaration. Second is what? Verification of registered office. The answer is this. You cannot go wrong because this is the recent thing that we have done. Don't expect the examiner to question you as per section 10A only. This is the way they question you. Hook or a crook, right or left, passive or active. You should be able to understand. Clear, everybody? Good. Next, 8th. Mr. A, B, C are willing to incorporate a company and issue share certificates in physical form. What kind of company can they incorporate? The answer is all those who are giving the answer as listed public company, extremely wrong and bad. Listed companies are not allowed to issue their shares in physical format. They have to compulsorily issue in dematerialized. We have done this. So the only answer here will be correct, will be private companies. Because private companies, it is optional whether to have demat or whether to have physical. Unlisted public companies, see any company which goes for public offer, demat. So unlisted public company means public offer. So demat is compulsory. So can you issue physical share certificates? No. So the only correct answer here will be what? Private company. All those who answered B, absolutely right. Those who gave D and A as the answer, bad show. Listed companies, imagine Reliance, Tata coming with physical share certificates. They'll become mad. The whole year will go in just organizing the working papers only. I mean the share certificates only. Clear, everybody? Next. For the contravention of section 42, that is private placement of securities, which of the following penalties can be imposed? Read correctly, answer me correctly. Everybody answer to everyone. There should be a competition, healthy competition in the class. Narsimha, Ankita, Sumaya, all of you, everyone. Yes. Others should see your answer and get confused. So there is a debate happening between A and D. So which is correct? You will decide and tell me. Nobody will cross-refer the textbook. Some people reply D, some people reply A. The answer is majority party wins. Okay, I think the printing mistake, I think D should be higher. Okay, A and B look same, right? So I think in one of them it has to be higher. So the answer is A. Correct, everybody? Clear?
Yes, ma'am.
Anybody who cross-checked with the book? Can you confirm the answer is correct? Because penalty, I told you, illogical. So even we don't remember the penalties. So can anybody give me the assurance it is correct? Section 42, prospectus topic. Private placement. Can anybody quickly check it?
Ma'am, A is correct, ma'am.
A is correct. Okay. Then move on to the next one, 10th. X Limited, a company incorporated in Chennai with its holding company in UK, may have different financial year by seeking whose approval is required for this. No debate, absolutely. Ablesh. The answer is C. Okay, everybody. The answer is C. Clear? Okay. Next. 11th one. If notice of general meeting doesn't mention the right to appoint proxy, then penalty again. So what will be the penalty? Ablesh, did you clarify the first answer? Previous one?
Yes, ma'am.
Yes, that is allocated to regional director, not to NCLT, okay?
Okay, okay.
Yes. Yeah. Come on, all of you, answer. Nobody's replying still. Quickly. See the way the questions are asked, huh? Tricky. Here matters how well you read. So I'm getting all types of answers. Some reply A, some reply B, some reply C. Okay. So what will be the answer? Here I can't even say majority because it's become 1/3, 1/3, 1/3. Okay. Understood the essence of reading correctly? Yes. So the answer is B. It is 5,000 can be imposed. Okay. Everybody, please go to your books. Topic of management and administration. Everybody will open the book. Management and administration. Go to the topic of proxy and look at the punishment there. I could also be wrong. So please cross check because penalty, even I don't tend to remember much. A penalty is like a liquidated damage. Okay. More than required. It could be unreasonable also. Okay. Penalties are liquidated damages, okay? Fines are already given in the law, very clearly defined. Penalties are additional, okay, extra amounts. It could be unreasonable also. The answer is B. So you can trust me for that. So I read better. Okay, everybody? The answer is B. Rest assured, everybody? Okay, next. Which of the following is a power of ROC? See, fines are already given in the law. Imprisonment already given in law. So what can be levied by the ROC? Penalty. Correct? The answer here is C. Okay, yes, the answer is C. Clear, everybody? Okay, next. Application money of the company shall not be less than dash and must have been received within dash days before the issue of prospectus or period specified by SEBI. This nobody should go wrong. If you go wrong, I'll screw you. One option you can easily rule out. Which is the option you can easily rule out?
B.
B. Okay, because 25% we never studied. So the options only remaining with you is A, C, and D. Out of that, which is the correct one? This do not go wrong. I'll feel bad otherwise. So you have a very good debate between A and C. Think over again and give me the correct answer. Is it A or is it C? Good that you have ruled out D also. So is it A or is it C? Okay. All right. Now I can say the majority party wins. The answer is A. The answer is A. Okay. All of you quickly prospectus topic. Go to allotment of securities. Quickly, all of you. Allotment of securities. What is the answer? 30 days. So understood the reading level, everybody. So all those who answered C, bad show. Okay, so the answer is A. This mistake should not happen again. Clear, everyone? So is the MCQ helping all of you? Minor reading will be clear with this. Okay, the small readings, which usually we tend to ignore or forget. This MCQs will help you out. Okay, everyone? Okay. Is anybody feeling if this is something boring or we should study the topic or you want this? Is it helpful to all of you?
Yes,
Good.
ma'am.
Okay. All right. Let's continue. 14th one. PQR Limited is in requirement of the funds and for such purpose, planning to bring private placement. There are several conditions for private placement. What are those? Out of these four, there is one important condition of private placement. Pick up which of them is it. Nitya, D1, read the next half also. Consideration to be paid in cash only. Answer is C. Clear, everybody? Understandable? Okay, next. In case of dash company, no member shall exercise voting on poll in excess of dash percentage of total voting rights of equity shareholders. Dormant company, we never studied anything about voting. Okay, so you can rule out that completely. IFSC companies also voting, we have not studied. So the option could be either A or it could be D. B and C completely rule out. The answer for this is D. Okay, everybody. Clear, everyone? So what is the exercise? Easy, difficult, or manageable? How many of you answered all correct? One wrong. Two. Good. So we did 15. How many of you get more than 10? Correct. Good. Okay. If your scoring is gone about 10 out of the 15, good. If it is going below 10, it's a long way to go. Okay. So is the exercise helping everybody? Overall coverage of all the topics. So this will help you understand whether you have got the things correctly or not. Yes, everyone? Okay, yes. Okay. Similar like this, in the next class also, I will be giving you one entire exercise of MCQ. But what I will do is, I will forward it to you maybe on Saturday. Okay, so that on Monday's class, you're prepared with the MCQ. You don't sit doing in the class. So that we can have discussion of only the answers in the class. Will that be okay to all of you? Okay?
Yes, ma'am.
Okay, yeah. So let us move on with the topic of acceptance and payment of deposits. Okay. Last topic in the company law. Chapter 5. Ready, everybody? Okay. The chapter 5 of the Companies Act 2013, which talks about sections 73 to 76A, talks about acceptance of deposits. Okay. Now, this topic basically talks everything about the deposits received by the company. Deposits is nothing but money received by the company, okay, in one or the other form, which will be recorded as deposits. If they are categorized as deposits, then the laws applicable to it will be different. That means the rules of 73, that is section 73 to 76A, will become applicable. But in this topic, what we need to understand is there are certain receipts which the company will have, some inflow of money which the company is having. Though they are receipts, we still will not consider them to be deposits as per the RBI guidelines. On deposits, more than the Companies Act, the RBI regulations will flow. Okay. So what will be the interest? How should be the repayment? All of that, the guidelines will come from where? RBI. You can accept the deposits in consultation with RBI. Okay. So what do you mean by deposit? Nothing but an amount received by the company. Okay. Some sum of money received by the company. And this is not the owner of the companies are the owner of this money. So obviously it is a liability which has to be repaid. Okay. And when you are holding money, is interest also payable on that? Yes. All right. But the first thing that you study in this topic is which are those amounts which you receive from the others, but still we don't call them to be deposits. Like, for example, loan from a bank. Will that be deposits? No. Security deposit received from the employees. Will that be deposit? No. Okay. So we are going to understand a huge list, a long list of all the receipt of money, which will not be considered to be what? Deposits. That will take up in the next class. In this class, we'll just start to understand the meaning of deposits, and then the remaining part will take in the next class. Clear, everybody? Okay. So all of you, please come to the chapter 5, page 5.1, acceptance of deposit by companies. Now, under that, the chapter 5 of the Companies Act 2013, consisting of sections 73 to 76A, and the company's acceptance of deposit rules 2014. Okay. Now, under that first definition of deposit, section 2, subsection 31. What is deposit? Deposit includes any receipt of money, that is inflow. Okay. Any receipt of money by the company by way of deposit or loan or in any other form. So whether you receive it as a inflow or a loan or any other form, if it is receipt, we call it to be what? Deposit. But RBI has clearly given list of receipts which will never be considered as deposits. That means section 73 to 76A or the chapter 5 of the Companies Act 2013 will not be applicable on these receipts of money. This list is coming from where? RBI. Clear, everybody? Okay, yes. So all of you, what is not a deposit? Deposit does not include such categories of amounts as may be prescribed in consultation with RBI. Okay, everybody? Okay, now if you looked at the question there, they have given you 1 to almost 21 items. Okay, though they are receipts, not 21, 26 items. Though they are receipts, they will still not be considered to be what? Deposits. That means these sections that we are studying in this topic will not be applicable to them. Okay, I will take everything of them in detail, but just for a summarized manner for you to understand. Like for example, amount received from governments, they will be categorized as grants. Correct? So are you going to show them as deposits? No. Okay, then loan from bank, their borrowings, will you show them as deposits? No. Loan from PFIs, again they are borrowings. Can you show them as deposits? No. Amount received from alternate investment funds. Okay, what is alternate investment fund? I'll explain in the next class. Okay, then amount received from a director, that also will not be considered to be deposit, but there are certain conditions attached to it. If you fulfill those conditions, only then we call that amount not to be deposits. Okay, then security deposit received from an employee. Security deposit. Okay, suppose you give loan, house and all to the employee. The deposits are received. Correct? Those will not be considered to be these deposits. Okay, these are not the deposits covered by section 73 to 76A. Okay, then amount bought by the promoters, capital contribution will not be considered to be deposits. Okay, next, amount received from another company will also not be considered to be deposits. So like this, we are going to study almost 26 items where you will see money is coming inside the business. They are not our money. Even then, we do not club them as what? Deposits. Okay, because the sections applicable to deposits are different. Rules applicable to deposits are different. Interest different. Okay, penalties different. Conditions different. RBI consultation required. Okay, so all of this is applicable to a deposit. Therefore, you need to understand every receipt, though we call it to be deposit, every receipt will not be considered as deposit by the RBI. Okay, so this 26 list is come from where? RBI. And RBI very clearly says these following 26 items, though there is money in flow, we don't call them to be what? Deposits. Clear, everybody? So all this 26 will take up in the next class, line by line in detail. Understandable to all of you? Okay, yes. Any doubt till here? From the previous topic, from the MCQ, any doubt? No? Okay. So we'll wind up the class here. We cannot take it forward because I cannot teach you like this in between. There are 26, all the 26 we need to do it together. Okay, we can't break it and study. Okay, so that is it for today. We'll wind up the class here. Thank you and good night all of you.